Jackson on behalf of the appellant petitioner, School Board of Manatee County, Florida. I would like to reserve 5 minutes. The school board has 2 cases before you following the denial of summary judgment on 4 counts against it, counts for negligent supervision and hiring, and 1 derivative claim. The matters before you today are a petition for certiorari and an appeal of denial of sovereign immunity to the school board on count 19. It's important from the outset for the court to understand that all of the claims against the school board hinge on Coach Joseph Canan's ability to establish the independent tort of malicious prosecution. If he cannot establish malicious prosecution, binding precedent by this court clearly establishes that the school board employer cannot be held liable for negligent hiring or supervision under Texas Skaggs versus Joanitis, 372 Southern 2nd, 985. I'm going to begin my argument, Your Honors, regarding the petition for certiorari, because that particular petition is dispositive of all of the counts. The trial court erred by finding that Coach Canan could establish malicious prosecution. The ruling was wrong because controlling precedent forecloses any possibility to establish the lack of probable cause when the reports at issue were mandatory under state law. Without
my understanding is that they were required to make a report of a legally sufficient complaint, correct?
That is correct, Your Honor.
And the allegation here is that this form or charge was based on knowing falsehoods, correct?
That is the allegation, Your Honor. However, the record establishes that that is not, in fact, the case. And Your Honor, if you look to
let me tell you what, I have a concern with your side arguing, and it's kind of cuts across all of the appeals and petitions, and that is, number one, the coach was interviewed and he said it was his responsibility to be sure the coaches were certified. But number one, having that responsibility is not the same thing as knowing that someone wasn't. And number two, we know that in fact it was not part of his job description to handle the certification, that he was supposed to pass that on to HR, which he did. And even though he said it was his responsibility, you've got a superintendent and the professional, the investigator for professionalism. They couldn't figure out that wasn't in his job description. It really concerns me that everyone seems to rely on his statements in an interview as opposed to what they knew the facts to be.
Your Honor,
I've said a lot, so
yes, and I'd like a moment to just kind of unpack what you said and
Sure.
explain our position on this, because number one, I think we have to start with the plain language of the statute, because what Mr. Canan's side is trying to do is impose additional duties and requirements on the school board that are not appropriate under the plain language of the statute. And if
the school board's responsibility is to adequately supervise, correct?
Correct.
But if these two fellows committed a malicious prosecution and the allegation is that not only was the school board negligent in that supervision, but one and maybe two of the members of the school board actively encouraged this behavior.
That is the allegation, Your Honor.
Right. So tell me why knowingly submitting false allegations to the Department of Education is not can't support a malicious prosecution.
Your Honor, the document that was submitted to the Department of Education is not false. Every one of the allegations that are included on that statement that was given to the department are accurate and undisputed.
So the statement is that Mr. Canan knowingly allowed a coach to coach without certification?
No, Your Honor, if you look at the employee reporting misconduct form, that is not included on the form at all. And so what the Mr. Canan side is doing is reading facts into the form that are not there.
So tell me what
And
what was the report? What did the form report?
yes, Your Honor. I'm so sorry. I had that in front of me just a moment ago. I need to pull that up for you really quickly. Apologize for that. So this is the employee reporting misconduct form. And it can be found at the petition number 135255 and 1352 through 55.
Okay. That's in the appendix.
Yes, Your Honor. And the form itself, and I'll read it to you, specifically states, Canan, while serving as the athletic director, had direct knowledge that the temporary certification for the head baseball coach, Dwayne Strong, had expired. That's true. That's undenied. The certification expired on June 10th, 2012. That's true. On Friday, it's blurry on this copy, unfortunately.
Sometime in October.
Oh, yes. Canan received an email from Roma Glisson, the human resources analyst at the School District of Manatee County, informing him of the expired certificate. That's undisputed.
But and correct me if I'm wrong, but my understanding is that's the first he knew that the certificate had expired is when he got that email.
Yes, Your Honor, I believe that's correct.
Okay.
And then on Friday, again, October, and the date is unclear, Canan sent Glisson's email to Coach Dwayne Strong, head baseball coach at Manatee High School. Undisputed. Coach Strong was allowed to coach during the full 2012-2013 baseball season and paid a stipend for doing so. That's true. That is all in terms of the summary of the allegation that is on there. His position is listed, excuse me, Your Honor, as business manager. And then under the summary of the allegations, Canan while serving as athletic director. And there's nothing on that form that is undisputed, Your Honor. There's no conclusion there at all.
Oh, there clearly is an implication, or the form wouldn't have been sent.
Correct, Your Honor. But
because if the procedure was that this was handled by HR and he told the coach to get with HR and sort this out, but is that in the form that he did that? No, what you've just read suggests very strongly that he knowingly allowed the coach to proceed without a certificate. When I don't know, it doesn't sound like it to me, frankly.
Well, that was the concern that the superintendent and the investigator had, that he did knowingly allow him to do that.
And they had that concern, but they also knew that it wasn't Canan's job to oversee that.
Well, no, Your Honor, that's not, in fact, what the record establishes at the time or ever. Truly, there may be a dispute about them later determining that. But let me, again, if I could, please go back to the language in the statute, because I really think it's critical here. The language in the statute says, this is 112.796. Each school district shall file in writing with the department all legally sufficient complaints within 30 days after the date on which subject matter of the complaint comes to the attention of the school district. A complaint is legally sufficient if it contains ultimate facts that show a violation has occurred as provided in 1012.795 and defined by the rule of the State Board of Education. The school district shall include all information relating to the complaint which is known to the school district at the time of filing. And there is no additional requirement for a full investigation at the time. Now, with regard to Mr. Canan's allegations about the job description and what have you, the record establishes that there was some discussion with Coach Canan back in 2005 and before 2010 regarding what his job would be and the nature of it and what have you. There was a significant number, if you look at the record, of turnover with regard to the position of superintendent. And Mr. Mills was not superintendent back at the time when there was apparently some discussion about Coach Canan and what he was doing with regard to the athletic director and business manager position. So in terms of what was known, that was what was reported to the Department of Education. And again, going back
So
to
did
the
they report
statute,
that when HR informed Coach Canan that his baseball coach was not certified, did they report that he then contacted the coach and said, go to HR and deal with this, and that was the correct procedure?
well, Your Honor, what the statute provides is that once this
No. What was put in the report? Was that put in the report? It wasn't in what you read a little while ago. What you
there's
read
no
was that he was aware the certificate had expired and the coach was permitted to coach.
correct.
The
And all of
implication
that,
being that he permitted the coach to coach without a certificate.
correct, Your Honor.
And it
And
would
what
have been
the
a very different, would have read very differently. It had also said when he was informed that the certificate was expired, he told the coach to contact HR and deal with it. And that was the procedure that was prescribed, that HR handled the coaching certification. But that wasn't
yes.
put in the report, correct?
Well, it depends on the report that you're talking about, Your Honor.
Well, I know you read me a report. You read me the report that got sent to, or the complaint or whatever got sent to DOE.
Correct, Your Honor. And what I read to you was the report that was sent to DOE, including the facts that were known to it at the time. I'd like to direct your attention to
Okay, so the superintendent did,
1357.
excuse me, the superintendent, you're saying the superintendent did not know what the correct procedure was and filed and signed off on sending this report to DOE.
Well, Your Honor, on October 22nd is the first time that Mr. Canan emailed Mr. Pumphrey a summary of his email with his exchange with Roma Glisson. That was after the report had been made to pursuant to the superintendent's obligations under the statute.
And the superintendent had no obligation then to pass this on to DOE?
Well, Your Honor, ultimately it was passed on to DOE because the entire baseball report was sent to DOE. And that was the internal investigation that was being conducted pursuant to the district's duties to discipline its employees if there's violation of internal rules and policies and procedures. The full investigative duty with regard to the employee reporting misconduct form falls on the Department of Education. There's two investigations that were running parallel. And the Department of Education's duty under 1012.796 is once it receives that legally sufficient complaint with the ultimate facts that are known to the district at the time, to the superintendent at the time they made the complaint, that's when the Department of Education launches its own investigation and does a complete separate investigation related to the certificate and for the teaching certificate of Coach Canan, having nothing to do with the internal disciplinary procedures. There's two different standards of proof that are at play, and they are completely different investigations. And so the DOE just looks at the EMRF, the employee reporting misconduct form, and conducts its own investigation. They got an affidavit from Roma Glisson during the DOE investigation. They spoke to HR. And so they're doing their own internal investigation with regard to that. And they ultimately found probable cause in their own separate investigation. They conducted full discovery. They did depositions. There's over a 400-page investigation that was completed by the Department of Education. Part of it included the review of the baseball investigation that was conducted by Pumphrey, but the record is very clear that Bonnie Wilmot explained that they do their own investigation. And Marian Lambeth, who explained, she worked for the Department of Education at the time, they don't want the districts to conduct these investigations. They want to be put on notice that there is concern regarding what is happening with regard to potential misconduct and violation of the professional rules of education practice and 1012.795, so that they can investigate expeditiously and address any complaint for the public interest. Your Honor, if there's no probable
Judge Northcutt,
cause
I think we lost.
Hold on,
we
Ms.
lost-
Jackson, and
we
I'm
lost somebody.
gonna stop your clock for a minute. We seem to have lost Ms. Seymour.
Yeah,
This is like NASA, you know, and I think she's coming back.
there's.
There you are,
I
Ms.
apologize.
Seymour.
I tried to, yes, our connection for some reason is unstable. I tried
Yeah.
to signal that a couple of times, and then it wouldn't let me rejoin, so
Okay,
hopefully it works now. I've
All right.
caught a few words. I think I've caught Ms. Jackson's argument, so.
pretty much. Okay, all right. Well, okay, Ms. Jackson, you can resume. I'm gonna start your clock again.
And
Thank you,
if
Your
I
Honor.
may, Judge Northcutt, can I interrupt right now?
Well,
I
you
want to be able
certainly
to. I didn't want to interrupt his flow. He was going quite strong. But Ms. Jackson, I'll tell you what my concern with, and I want to be able to have you address this before your time runs out. This is before us on a writ of certiorari. One of you started with this. And as you know, with a writ of certiorari, you have to, it's an extraordinary remedy. One of the things you have to be able to show that there's been truly irreparable harm. And I'll tell you what I'm concerned with to give you a chance to address it. You're taking the position that because there's uncertainty in the law and the possibility that you all may have to change your reporting policies. Why is that irreparable harm? It's really not irreparable harm, and I want you to be able to address that.
Thank you, Your Honor, and I appreciate the opportunity to answer that question. That actually what our position is that the lower court's ruling is causing irreparable harm to the department and the state's education system as a whole, because the harm will both continue through the rest of this case, and it cannot be corrected on a post-judgment appeal. In that right now, what's happening is that educators are caught between having to decide whether to comply with the law and report those ultimate facts that show violation of the statute, or face personal liability for malicious prosecution for violating the law by not making the mandatory reporting. And so that is
I think the question here, though, is you know, did they knowingly submit a false or misleading, whatever the EMS, whatever it is, that form to the DOE? Because if that's the allegation, if that's what the proof is, then it doesn't, this litigation doesn't really put all administrators between a rock and a hard place. All they have to do is be honest about it. But if they intentionally submitted false or misleading information to the DOE, that's a whole different matter.
And to follow with that, Ms. Jackson, what concerns me, you mentioned the department. The department is not a party here. Can you get cert for harm to non-parties? So in addressing that, I want you to keep that in mind.
Well, Your Honor, it's not just for the department. It's with regard to our educators that are employed by the school board and the superintendent of the School Board of Manatee County. I mean, we are now in a position to where if the superintendent does not report what appears to be ultimate facts that show violation, again, remember, we have a timeline to report these things. It's not once the investigation is complete. It's within 30 days of notice of a potential violation. Okay. And if it's for the safety, safety, health, or welfare of the students, it's immediately we have a duty to report. And failure to report could result in the withholding of the salary of the superintendent for an entire year pursuant to statute. There are very serious consequences for failing to report. And so the irreparable harm is due to the fact that now we're in a situation where we have to decide, does the superintendent have a duty to report this? Because we're putting them in a position to determine legal sufficiency, which is not at all what the statute provides. That's what DOE's job is. So the report is submitted.
Well,
DOE
doesn't the statute place upon them the burden to submit a legally sufficient complaint? And doesn't the policies, and you know, I'm forgetting whether this was internal or external, but you know, you have to have that reviewed, you know, by the school board attorney or the school system attorney, at least, I guess, for legal sufficiency. Correct? So it's not like they can just send it up there and hope it's legally sufficient. There is a requirement they make some sort of preliminary determination of that.
Well, but what that is that it contains ultimate facts that show a violation known to the school district at the time. So known to the superintendent, because it's the superintendent who would forfeit his salary for a year if he does not report it.
But is
So
that,
this
Ms. Jackson, if I may, that's not
Sure.
irreparable harm. He can always recoup all that money later on. Irreparable harm, that means there's absolutely no remedy whatsoever, and the person is totally so. Again, you're bringing it up on cert, and cert based on the case law is a very extraordinary remedy. So I'm having a hard time seeing, based on this record, which we don't have a transcript of, where is the irreparable harm in this situation? So help me out.
Your Honor, the irreparable harm is to the students. The irreparable harm is to the fact that now there is a chilling effect on these educators within the school board of Manatee County to not report, and for the superintendent to not report, because if he reports, then he can be and there's some challenge, then in this situation, he's been subject to litigation for an 8-year period for malicious prosecution, when there's mandatory reporting and pursuant to the statute, and there should be absolute immunity pursuant to Merrill and Rosen.
Well, okay, let's talk about.
So you're suggesting that we should make that policy absolute immunity, because that's
Yes,
not
Your
what's
Honor.
in the case law currently, or statutory law, correct?
Well, it is not in the statutory law, Your Honor, but I do believe that under Rosen and Merrill, the footnote in Merrill, that
By
absolute immunity should be imposed.
analogy, there's no law that says school administrators have absolute immunity.
That is correct, Your Honor.
And let me get back to Merrill, because I know you cited that case, Ms. Jackson, but Merrill is a lot different from the case here. First of all, it was not up on cert, as you could probably agree with, and it dealt really more with the sufficiency of the evidence at a jury trial, not immunity from suit based on papers that here. And also in Merrill, and I pulled it out right here, the statute is different than what we have here. So I'm having, again, a hard time understanding your reference to Merrill under the facts of this case.
Well, Your Honor, and with regard to Merrill, I would say that actually our facts are even more favorable to the school board and to the employer. And that is because in the Merrill case, if you look at footnote 3, it specifically says that the court was concerned about policy implications associated with a malicious prosecution claim based on a statutory reporting obligation that the court noted its inclination to recognize an absolute privilege against liability for making confidential complaints with the department for the same reasons that complaints about lawyers are absolutely privileged under Rosen. And under that statute, and that was at issue in Merrill, there was a qualified privilege. And so the court didn't go so far as to say there should be an absolute privilege because of the qualified privilege in the statute. In this case, we don't even have a qualified privilege in the statute. And so, again, we're concerned about policy implications. We're concerned about the welfare of these students in the classroom
Okay,
when
let's go back.
superintendents.
If I may, Ms. Jackson, okay, because neither,
ma'am.
I'm looking, neither 1012.795 nor 1012.796 mention any privileges or immunity.
That is correct,
Agree
Your
with
Honor.
that? Okay.
I do.
Okay, so again, it just, there's really no privilege in the statute. This is where I'm trying to understand your position about Merrill. Merrill dealt with a very specific statute, and that specific statute, actually, it indicated that, and I quote, "Here, the defendants were protected from civil liability for furnishing information to the department by section 455.225 subsection 10 unless they furnish information in bad faith and with malice." And in here, I don't think the school board has identified any such statute granting it similar protection. This is what I'm having a hard time, if I may. And I know your time may be come to a close, but I just want to be able to ask you that.
Yeah, I would want to point out that I and mostly me and Judge Kazam as well have helped you use your time up to your rebuttal time. So proceed as you wish.
Thank you, Your Honor. Well, Your Honor, I would also like to point to the case of Stone versus Rosen, 348 Southern 2nd, 387, which I think would also address your questions, Judge Kazam, with regard to whether there should be something specifically in the statute. And in that case, we're looking at an issue with regard to the Florida bar. And essentially, if we look at, this is at page 389, it states, if each person who files a complaint with the Ethics and Grievance Committee may be subject to a malicious prosecution action by the accused attorney, there is no question but that the effect in many instances would be the suppression of legitimate charges against attorneys who have been guilty of unethical conduct, a result clearly not in the public interest. And that's the same that we're talking here. And Your Honor, there was nothing in the statute specifically addressing that particular concern. There's nothing in the statute regarding immunity when the court, the 3rd District Court of Appeal, was looking at Stone versus Rosen, but they specifically created absolute immunity in those circumstances and also certified that to the Supreme Court with regard to judges. And it's the same in this instance.
Of course,
Your
there
Honor.
wouldn't be a statute because the legislature is not in charge of the bar. So there wouldn't be a
Yes, Your
statute anyway.
That's correct. That is correct. But they did feel
Here
that it was
there's
a-
statutes, right? Here there's a statute.
Correct. But they did feel, the 3rd DCA did feel that the subject was so important that it created the absolute immunity. And again, it's for the same, and certified the question to the Florida Supreme Court. And again, it's for those same reasons. It's concern related to the chilling effect that this type of a determination would have. And under the statute, again, the school district was merely complying with its obligations to report as provided under 1012.796. Failure to do so could have resulted in serious penalty. And now we are caught in a situation between Scylla and Charybdis, because now superintendents are having to decide, what would I rather? Would I rather be subject to 8 years of potential personal liability and litigation for malicious prosecution, or would I rather risk violating the law and having my salary withheld for an entire year? So, Your Honor, we ask that you please follow Texas SCAGs in determining that there is no liability for the school board for negligent supervision or negligent hiring, because they cannot establish malicious prosecution, as there is a mandatory reporting requirement under the statute, and probable cause. There is no lack of probable cause due to that mandatory reporting requirement. And we ask that you please comply with Merrill and with Rosen in establishing that the school board has no liability in this case. Thank you.
Thank you, Ms. Jackson. And I'll, you know, on the rebuttal end, I'll leave you 3 minutes.
Thank you.
Okay, Ms. Seymour.
Yes, Your Honor, may it please the court. My name is Jennifer Seymour, and I represent the appellees, Joseph and Linda Canaan. And I will apologize in advance if I get frozen. It's been freezing up this whole session. So I'd like to start with trying to separate out. It seems like the school board continues to conflate the issue of duty and with the conduct of the malicious prosecution claim. And in trying to get to the show of irreparable harm, the school board improperly conflates the reporting requirements with the false and malicious reporting, which took place in this case. And they repeatedly denigrate the Canaans for what they characterize as retaliatory litigation when they were constitutionally entitled to redress the tortious conduct they suffered in this case. The Canaans were not merely inconvenienced, but subject to years of litigation with FDOE and his decades-long career hung in the balance in the meantime. And the scare tactics that are being used overlook the obviousness of the necessity under the statute to provide a legally sufficient complaint. That is not what happened here. This special mechanism of the writ is not an appropriate vehicle, and they've already undergone the interlocutory appeal on the basis of denial of summary judgment to sovereign immunity. This writ is discretionary. It was never intended to redress mere legal error, and it's an extraordinary remedy, as the court has already pointed out. The school board has failed to show a departure from the essential requirements of law, resulting in material injury for the remainder of the case, which cannot be corrected on post-judgment appeal. And as this court has pointed out, the reliance on Merrill and Rosen is misplaced because those cases are distinguishable from this instant case.
Ms. Seymour, what do you make of the suggestion that in a certiorari proceeding in which we're supposed to search for a departure from the essential requirements of law, that we should, in that process, announce a new policy that school administrators in these circumstances are absolutely immune?
That's way beyond what the legislature required, and it's way beyond the purview of this court. It's also not necessary in this case. The school board has a history of conflating the submission of this report, which in fact was false and incorrect, and that is also under the statute part of what they're not allowed to do. We're not asking for new law to be created. We're not asking for a change in the way it's interpreted. We have no problem with the policies that existed. That's part of the duty that the school board undertook and failed in this case. And yes, Your Honor.
No, I'm sorry, I didn't mean to interrupt. I was just drawing back breath to speak when you finish.
Well, I saw your mute go unmuted.
Oh, okay. Oh, I'm sorry. I didn't realize you could see that. Oh, good. That's good information to have on this.
Yes, Your Honor. It's unnecessary. That is not the extraordinary remedy we're asking for. We're not asking for any of that. We believe that the trial court correctly found that there were numerous disputed issues of fact. And no matter how counsel for the school board or the individual attorney have characterized it, that's just not the situation here.
Ms. Jackson has pointed out, and this goes to the underlying tort of malicious prosecution that would have to be shown in order to hold the school board liable as under a failure to supervise theory. She's pointed out that whatever the insufficiency, misrepresentations, improper implications are or were in the report to the DOE, that the DOE conducted its own investigation and found probable cause. How does that affect this proceeding?
Those are different things. The school board has its own duties that are prescribed under the statute. And as the court has pointed out, they have to be legally sufficient. There has to be a number of things that they carry out and make sure that they're not false. In this case, because of political and personal animus, against Mr. Canan that was between the school board superintendent, the investigator that he personally hired and installed and failed to supervise, and the school board failing to supervise these people. They did not submit a legally sufficient complaint in the first place. And they can't just knowingly do that and then rely on the fact that it was submitted and rely on a different department to do their jobs, which, by the way, the FDOE did. They found that there was nothing to this. And Mr. Mills, the superintendent,
It's my understanding that the FDOE found probable cause, but then determined that they couldn't prove the case.
they dismissed the action because there was no basis to Mr. Canan having the role that was suggested by Mills and Pumphrey at that time. And that the school board knew that. This was a submission made to force Mr. Canan into retirement. And there were many times where it was suggested he would either retire or be fired through this pressure that was being put on him. The school board seems to admit that it had duties because it's outlined in the statute and there's built-in safeguards. The mistake that the school board is making is assuming they acted consistently with their responsibilities. And the record evidence shows that there are disputed issues of material fact in this regard. That's why the trial court found what they did, and that it was not subject to sovereign immunity, either under count 19 of the negligent supervision of meals that the school board is appealing in the interlocutory appeal, or all of the counts against the school board that they're attempting to do and asking for a writ.
And it's interesting, Ms. Seymour, because, you know, for the malicious prosecution, if you look at I know what the court said about there's factual disputes. And if you look at the record, what jumps out at me is like few things. Quote, Keenan, I think, testified that when at least Pumphrey first met with all the sports coaches, he told them, and I pulled this out, quote, "You are all cheaters. You all break the rules. You haven't been caught yet," close quote. And then looking at the record, Mr. Gagnon testified that, quote, almost immediately after Pumphrey was hired, the role of the investigator was, quote, very intentionally changed so that he would report directly to Rick Mills instead of the staff attorney, quote, in order to have direct control over the investigation and the direction it was going and the outcomes, close quote. And then the record shows that Pumphrey's first investigation of Keenan, it began with a complaint about a different coach, but then he used to investigate Keenan instead. He accused Keenan of failing to check with other coaches. And Keenan testified, and this is in the record, that Pumphrey was malicious towards him, tried to intimidate him, harassed him at the direction of Supervisor Mills, and specifically was told that Mills wanted him to retire and that he would make the investigation all go away if he would just retire. So all of these things, there's also that Pumphrey was Mills' hitman, they orchestrated. So the court has seen all of this, came to the conclusion, these are all factual issues that for the jury to make a determination, if they come to the conclusion that this falls within, enough evidence for actual malice, so be it. And so having all of this before us, and then going back to what Judge Northcutt said, the school was trying to ask us to take a position on something that based on the record, it just appears there's a lot of factual issues to be resolved. We're not there yet. And then on a certain standard, this all concerns me, and that's why I want to be able to give you the opportunity to address it.
Yes, Your Honor, and there are additional facts that were in front of the court. There was 104 pages for summary judgment that was filed by the school board with 168 enumerated paragraphs for facts, and another 51 pages, 25 pages of facts that were filed on behalf of Mills and Pumphrey. In addition, we set out in the plaintiff's response to the motion for summary judgment, the facts that are actually in dispute. A lot of times the parties will characterize something as being undisputed when they're actually conflating a time frame or different reporting requirements. They ignore also, for instance, that there is a duty to ensure that elected and appointed officials they will forfeit salary. They will suffer consequences if they knowingly sign and transmit to any state official a report of alleged misconduct, which an official knows to be false or incorrect, which is exactly what happened here. There's also concern that the investigator himself was not qualified for the original position. They changed the position, they changed who he would report to, and the school board was aware of this and failed to supervise adequately. It's not about the failure to fire Mr. Mills. It's about the failure to supervise him, knowing that there was this political and personal animus that he had announced. He had made it clear in meetings, and this was also part of what's been alleged, at least at this point, and remains a disputed material fact for the jury to decide as to how this all transpired. There were some interesting things happening in the politics of Manatee County School Board, and that all preceded this, but it's interrelated because it's part of why this strange fact pattern emerged, which, you know, in what the school board suggests, there's going to be a chilling effect and superintendents won't know how to react. The allegations that have been made in this case, again, they remain disputed at this point. That's why a jury needs to decide these issues, but they're pretty egregious. I mean, when you look at the conduct that was repeatedly occurring with these school board officials and at meetings, and two coaches that have been 3 decades long in a career, these are school teachers. I come from a family of school teachers. It's incredible to suggest that superintendents throughout this great state of ours are going to have to be concerned about this chilling effect or not be able to perform their jobs because it's already prescribed by statute what their duties are. That's not the issue. It's the issue that they failed to do those. They failed to comply with their own policies and procedures, not that we need to create new ones. If the appellant had the school board had no duty to supervise Mills, then how could the school board meet its mandatory obligations under the statute? It's nonsensical. The appellant falsely suggests that it's undisputed that Mills and Pumphrey acted in accordance with both policy and statutory law in their responsibilities, and they repeatedly say that, but those are material facts that the trial court found to be in dispute, and we agree they are in dispute. They're not entitled to sovereign immunity under these issues. And here, we're not seeking to hold the school board vicariously liable for which sovereign immunity would apply. We're rather holding the school board responsible for their own negligence in failing to supervise. Once the duty is established, the courts must determine whether the governmental entity is entitled to sovereign immunity. Here, that is not a claim for negligent hiring or retention of Mills. It's the negligent supervision of Mills, and I think that's an important point as well. And the allegedly tortious act, again, is not to failure to fire Mills, but that the school board should have done something knowing his predisposition towards animosity, removed him from the investigation involving Mr. Canan. Whether Mills was exercising discretionary power to enforce compliance with the law is not at issue. And we agree the duty to submit a legally sufficient complaint is part of what's already under the statute. That did not occur here. That's the issue. And that's the issue that the court found. So it's not about how Mr. Mills supervised Pumphrey the investigation. It's that the school board was responsible for Mills's conduct, the superintendent's conduct in performing, making sure that they were complying with the policies and procedures that already exist. And the school board breached that duty by failing to ensure that Mr. Mills complied with the already existing policies and procedures. So it's not about failing to adopt policies and procedures, which would be discretionary. This is about the operational failures. And appellants have taken inconsistent positions throughout this. On the one hand, they argue that Mills and Pumphrey were required by statute to file all complaints and had no discretion as to whether or not to do so. That would clearly be an operational function. On the other hand, they contend that the supervision of Mills was a discretionary function, despite similar statutory mandate requirements that the school board would discipline Mills if he knowingly submitted a false complaint. I think all of the cases that have been cited are distinguishable, and in terms of the writ itself, the reliance on Merrill and Stone and Rosen is completely misplaced. And they repeatedly conflate what happened in this case with child abuse and really egregious acts that are not at issue here. Mr. Canan had no responsibility to do anything further than to tell a coach to get certification, but he couldn't look it up himself. The HR department and Roma Glisson were responsible for looking at who had certifications. They were the only ones, HR department was the only one that could access that information, not Coach Canan. Coach Canan wasn't the athletic director. He was a business manager. There was a different role. And that's still kind of being conflated, the different roles that he supposedly had, which we know he didn't those. But I mean, either way, they remain disputed issues of fact. Here, the complaints did not relate to the abuse, the health, safety, welfare of any of the students. And there is no privilege from civil liability, as there would be in Merrill. In Merrill, a jury found the defendants guilty of malicious prosecution of a registered nurse. And as this court has pointed out, the nurse it was under certain statutes that relate only to nursing care. Merrill does not involve the threat of political retaliation. Merrill does not require an independent investigation or determination of legally sufficient complaints prior to submission. The nurse is filing the reports pursuant to a specific section in the code had qualified immunity. So that is not analogous here. And this is not a defamation case. This is not about child abuse reporting or the federal banking statutes that the appellant repeatedly cites. The focus has been from the appellant's perspective for a very long time about the submission itself. But what is really at issue here is what happened leading up to the submission. The failure on the part of the school board to supervise properly and to remove Mr. Mills from an investigation of Canan when it became obvious he had his own personal and political animus and his own reasons for doing so. The failure to not supplement information to the FDOE when it was obvious to all of the people that were involved that was not Mr. Canan's job, and that was a failing on the part of HR. The other thing I'd point out, not to get bogged down in the weeds here with the facts, but Mr. Canan had no ability to pay Coach Strong, to keep paying Coach Strong, and the school board did. And they continued paying him even with this issue of expired certificate. It's nonsensical that somehow this is then a legally sufficient complaint when it's just a mechanism to try to force Mr. Canan into retirement or to fire him.
And let me ask a question in that regard. There's evidence of a conversation in which Pumphrey told Canan that if he would retire, all this would go away. Correct?
Right, Your Honor.
Is my understanding that the reporting requirement applies even to teachers who have left the employ of the school system?
That's my understanding. Part of this issue was the carrot, so to speak, was given to Mr. Canan. If you retire, well, this will all go away. But actually, there was a second report that had already been transmitted that also was false.
But my point goes to how can it all go away if they continue to have a duty to report?
Correct. It doesn't make sense, Your Honor. And that's part of what the jury would ultimately have the role to decide in this. And it should be the jury to decide. The trial court correctly analyzed the issue, found the record was replete with disputed issues and material fact, to which sovereign immunity does not apply. And going back to the temporal component of this, it's not just that Mills and Pumphrey submitted the report and know that they were false. It's all that led up to what was that submission. It was an excuse to try to get rid of Mr. Canan. And at the time, Mr. Canan was under a contract and only being terminated for cause. Whether Mr. Canan was actually responsible for ensuring that the baseball coach had a current coaching certificate remains a factual dispute at the heart of this litigation. His actual job description for business manager, though, was silent as to any duty. to monitor the coaching certifications. And although there's a catch-all provision that, other duties at the discretion of the principal, he wouldn't have had the ability to even see if the coaching certificate existed, that he didn't have access to. But again, the HR department and the school board did. And they knew that at the time that these were submitted. Does Your Honor have any other questions or things that we could elucidate?
Nothing from me.
I don't think so.
I'll leave my time there.
Great. Ms. Jackson, you're up for rebuttal.
Thank you, Your Honor. Your Honor, pursuant to its statutory obligations, the school board implemented policy 6.13. And it did so in order to ensure that when allegations regarding educator misconduct come to the attention of the school district, that it has policies and procedures in place to comply with its statutory obligations for mandatory reporting of legally sufficient complaints.
Is that the policy that required that that Pumphrey passes through legal?
Your Honor, there is a reservation of discretion with regard in embedded in the policy.
Is that what it says? That if need be, he'll pass it through legal, or was that a requirement of the policy that legal pass on the legal sufficiency of the report or the complaint?
Oh, Your Honor, I'm trying to put my hands on 6.13 right now. The actual policy language I had a moment ago.
Because, consider this possibility. The school board is being accused of negligent supervision. And it seems to me that if the policy said that people it was supposed to be supervising had the discretion whether to get legal's imprimatur on the legal sufficiency of the complaint, that alone might be negligent, might it not?
Well, Your Honor, pursuant to the policy 6.13, there is a flow chart that explains how the process works with regard to receiving the information and then processing it through. And it specifically states that a case file is created. There's a consult with the staff attorney and the school board attorney when appropriate to determine the course of action, and then an investigation is conducted. And that is what happened in this case.
Was there a consult with a staff attorney in this case?
Your Honor, I can't speak to that. I am not certain exactly what the record says in that regard. But there was certainly an investigation that was conducted, and it's not been an allegation that has been brought forth that with regard to the staff attorney or the school board attorney not being consulted specifically. I don't believe.
I know I read it somewhere in these various briefs that and clearly that had to have been supported in the record.
Well, Your Honor,
because my understanding is Pumphrey just took this straight to Mills and didn't take the staff attorney, and Mills apparently didn't direct him to.
Your Honor, with regard to that, I will say that even if that is the case, and if there's a dispute of fact in that regard, or even if the facts show that, that's not really relevant to the ultimate question here of reporting it to FDOE, because there are policies in place, but the failure to follow those policies doesn't lead to malicious prosecution, internal policies. What would lead, the FDOE has required that legally sufficient complaints be reported. Those reports are those that show ultimate facts that there has been a violation of the statute. And ultimately, what was determined in this case is Marian Lambeth, the former bureau chief, stated that she is constantly telling school districts that they do not need to finish their internal investigation before making a report. And that is at 1544 line 17 through 15454 and 155511 to 155516. She repeatedly explained that the investigation is not to be completed or conducted internally by the school board before it's submitted. The statute very clearly puts a deadline of having to report within 30 days or immediately if it is something that would jeopardize the health, safety, or welfare of a student, which, Your Honors, the FDOE actually found probable cause to believe that it actually did that. Even though the certification
did not directly involve the health or safety of anyone. It really was a requirement for the coach to be paid as a coach.
Yes, Your Honor, that is correct.
So-
But ultimately, the DOE found probable cause to file an administrative complaint, and that is amongst the allegations with regard to what they determined after conducting their own investigation.
But
And
which it then dropped for lack of evidence.
it did, Your Honor, ultimately decide not to pursue that, but Bonnie Wilmot testified, and she was one of the attorneys, one of the primary attorneys on this case, that she believed there was still probable cause, and she wanted to continue to pursue it. So, why
Okay,
exactly?
I've let you go 5, or I've helped you go 5 in rebuttal, so you need to wind up.
All
Jackson.
right, thank you, Your Honor. Ultimately, the school board asks that the petition for certiorari be granted and that the lower court be directed to follow the law in Merrill and in Rosen and enter summary judgment in favor of the school district on all counts, and alternatively to grant sovereign immunity as to count 19 because the superintendent and the hiring and training and supervision of the superintendent is a discretionary or planning function for which count 19 would, sovereign immunity would apply. Thank you,
Okay.
Your Honors.
Thank you. Thank you both very much. Ms. Jackson, you performed well under fire. At this point, I typically tell the lawyers, how to leave the Zoom session by clicking the leave icon in the lower right-hand corner of the Zoom screen, but I'm unaware of what your situation is in terms of whether you need to be totally out of, are you there with other attorneys? Maybe the marshal can tell us, would you just be put on the non-arguing part of the session if she's listening? All right, we'll sort that. The court will take a 10-minute break here before we start our next combined argument. And if you, Ms. Jackson, if you want to leave the Zoom session altogether, click the icon in the lower right part of your screen. It says it's either just the word leave or it's a pictograph of a human going through a door. And if you click that, you go off into the ether. You obviously can still watch on YouTube and so forth, but